Get ready. 3 seconds. 2 seconds. Start. The order of conviction dated 23/2/95 passed by the additional session judge in sessions case number 67/92, thereby holding the appellants guilty of offense punishable under sections 302/34 IPC and sentencing them to undergo imprisonment for life with a fine of rupees 5,000 or in default or payment of fine to suffer 6 months RI aggrieved by the said conviction and sentence, each accused has been preferred his separate appeal. They have been heard together and disposed of this judgment. Para. On completion of investigation, which has been criticized as highly tainted, the accused appellants were charge-sheeted and tried for the above offense. Their defense at the trial was one of the plain denial of the prosecution case and false implication. The trial court, however, found them guilty and sentenced as already noted above. Hence these appeals. Para. Learned counsel for the appellants have raised the following points. That there is no eyewitness to the incident. The circumstances relied upon by the trial court are not established, nor are they sufficient to sustain conviction. The judicial confession as recorded by the magistrate, Exhibit 11 and 12 are highly tainted and suspicious documents and should have been discarded by the trial court, instead of placing intrinsic reliance on them. The conviction is based on total misreading and misappreciation of evidence without any regard to realities of life and human probabilities. The trial court has mistrued Section 27 of the Evidence Act. Para. Learned public prosecutor appearing for the state, on the other hand, maintained that notwithstanding the discrepancies and infirmities pointed out by the learned counsel for the appellants, the conviction as recorded by the trial court is fully supportable by circumstantial evidence as relied upon by the trial judge, which does not call for any interference. Para. Incidentally, these very infirm and discrepant aspects of the evidence of PW3 have also a vital bearing on the extrajudicial confession made to him by the appellants, circumstance number 3, as noted by the trial court. Even according to the learned trial judge, as noted by him, PW3 prevaricated in his examination in chief about the alleged extrajudicial confession, but his statement, Exhibit 8, recorded under Section 164 CRPC by a magistrate, PW10, proves it. The learned trial judge has fallen into an apparent error of law in treating such a statement as Exhibit 8 as substantive evidence which It is certainly not. Full stop. The statements recorded under Section 164 CRPC are not substantive evidence in a case and cannot be made use of except to corroborate or contradict the maker thereof. Full stop. Para. It has come to our notice in this case that the incriminating articles were sent to the State Forensic Science Laboratory through the Chief Judicial Magistrate, this is equally objectionable. It should be left to the investigating agency, to pursue its investigation in accordance with law. Full stop. It is the responsibility of the investigating agency to see that the incriminating articles seized or recovered during investigation requiring further chemical or ballistic examination are preserved and kept intact till their dispatch, which must also be promptly done. Full stop. It is no part of duty of Chief Judicial Magistrate or any other judicial magistrate to step in at this stage of getting such articles examined by the State Forensic Science Laboratory. Para. In view of the foregoing discussion, both these appeals are allowed. The conviction and sentence as recorded by the trial court are set aside. The fine, if paid or deposited, be refunded to the accused appellants. Full stop. The appellants are acquitted of the charges framed against them. They be set at liberty forthwith. Stop.